Julia, I have asked you to come and see me about the aluminium company case. We act on behalf of the company and get instructions from Harry Ingle, the managing director. I have given you a copy of the claim.
Yes, Stuart. I got your email attaching the claim.
Just by way of summary, Harry entered into a contract with Patricia Hemming. She is the managing director of the Helix Engineering Company. The contract came about as a result of a tender process. Helix Engineering was the successful tenderer to construct a blast furnace at Harry's Gladstone aluminium refinery for a cost of $20 million. The project is now 12 months behind schedule. Harry argues that Patricia's company has not complied with the terms of the tender document. There have been cost overruns and delays associated with the foundations. We have commenced proceedings on behalf of Aluminium Pty Ltd in the Supreme Court seeking damages for breach of contract.
Has Helix Engineering Pty Ltd filed a defense?
Yes, they have. Helix Engineering argue that the cost overruns have been due to encountering an unexpected water table that had not been detected by the original soil tests or mentioned in the hydrology report. This water table had to be drained and capped, resulting in extra cost and delay. They argue that this is covered by a clause in the contract and tender documents dealing with unforeseen events.
I see. What would you like me to do?
As you are new to the litigation process, I thought that this would be a useful learning experience for you. I would like you to work with me and sort out several issues related to disclosure. They call it discovery in some jurisdictions. I have given you a flow chart of the process to make a decision on whether information needs to be disclosed to the other side.
Happy to assist, and yes, I have had a look at the flow chart.
Harry has provided us initially with 9 pieces of information, which I would like us to work out whether they should be disclosed under the Supreme Court rules. The first piece of information is a copy of an expert hydrology report commissioned by and provided by Hydrologyros Limited to Helix Engineering. It was provided to our client as part of the defendant's tender submission. Julia, the first step is to work out whether this is a document. Where do we find the definition of a document?
Sorry, Stuart, but I have no idea.
Come on, Julia. Have a look at the flow chart. You can work it out. What is the answer?
A document is defined in the Act's Interpretation Act 1954, Queensland, Section 36, and also in the Evidence Act 1977, Queensland, Section 3, and in Schedule 3.
That is correct. Well done. Let's consider the first piece of information Harry has given us. It is a copy of an expert hydrology report commissioned and provided by Patricia. It is obviously a document, but is it directly relevant to the action? Remember that is one of the requirements of UCPR Rule 211.
No, it is not relevant to the issues.
No, that is not correct. The document is directly relevant to the issue of whether the water table was a foreseen event or not. Is the document in our client's possession or control? This is another element of UCPR Rule 211. If the document is not within your client's possession or control, it need not be disclosed. What do you think? Is the document in our client's possession or control?